Deji, thank you so much for joining us. I appreciate you for doing this with us. I mean, I have to state by saying, what is your take with this ruling dismissing the suit filed by the 16 states? What's your take on that? Let's start there.
Good evening. Thanks for having me.
Thank you for joining us.
Like I said, I am excited by this judgment, the judgment of the Supreme Court, and I commend the Supreme Court for reaching this very rich decision, one that has affirmed the powers of the EFCC and all the other two federal bodies to not only investigate but prosecute persons at all levels of government for crimes relating to corruption. I had stated during an interview on News Central before that there is no explanation for the actions of the states other than that it is for selfish reasons. For selfish reasons, and my opinion, which of course the Supreme Court has already affirmed too, that it is for selfish reasons, is on two accounts. First, those states who have been, whose former governors are currently being tried, like Kogi State, are doing all that they can do to give a soft landing for their predecessors. Secondly, the recent Supreme Court decision that, explained, that further expounded the nature of the autonomy of the local government areas or authorities is one that is scary for current or sitting state governors, because it takes away a lot of financial powers from them. A lot of governors in the past have been feeding fat on their allocations to the local government, and the current ones cannot imagine themselves not being part of this largest. And so the essence of this whole court action is to avoid the consequences of the decisions of the Supreme Court and to help their predecessors avoid prosecution, or for those who do not have good relations with their predecessors, to ensure that in future they themselves are not hounded or prosecuted by the EFCC. And I think the fact that it is also a unanimous decision is something that is also exciting. Of course, we cannot quarrel with the states that went ahead and instituted this action. It is good. What they have succeeded in doing is to enrich our jurisprudence in this area. They have succeeded in fact, for some of us, we have learned some new things from the decision of the Supreme Court.
Right.
We have learned now to distinguish.
Yeah, but did you have to ask?
Conventions and treaties for the purpose of ratification.
Right. I'm glad you were getting there, because I was going to ask you to distinguish between what a treaty is and what a convention is, just for the sake of our viewers. But also, does this mean that, did they even have a case to begin with? Did they even have a case, the 16 states, removing the fact that, I mean, you just stated this was in some way to give the immunity to their predecessors or successors, and then citing Kogi State matter. But do they even have a case to start with? And what exactly is a treaty or a convention?
Like I said, when I appeared on News Central here to discuss the same issue, I stated that I expect the Supreme Court to throw away the suit with alacrity. It has no merit. There is no way you would be able to substantiate the arguments of the states that the federal government does not have powers to set up agencies to investigate corruption at all levels of government. It is an anathema to the fundamental principles of accountability and transparency in governance. And these are very essential for the nation's progress. And you will know that over the years, I think every one of us have always, including the sitting governors, we have agreed that the problem with our country, at least for the main part, is corruption. Corruption in every sector. How then can you now remove one? I mean, those who have lent themselves to govern, to lead, and to manage our resources, how then that you now excuse them from such scrutiny? I don't think it would ever stand any form of logic. So it is clear that the message is that corruption and its enablers will not be allowed to escape scrutiny or shield themselves under the guise of jurisdictional conflict. Now, as regards the distinction between the convention and treaties, the Supreme Court's position is that a treaty is essentially between a few countries, whereas a convention is one that is between a larger number of countries, and it needs to be ratified. Now, treaties would need to be ratified by 2/3 of the state houses of assembly for them to have effect in Nigeria, but conventions are not. And the EFCC Act is not a treaty, one. It is not even a convention. But of course, the principles therein are drawn from the convention, and so it does not need the ratification of the state houses of assembly. This is the position I have held, and so I do not think the states had any chance whatsoever in succeeding in this suit.
All right. I mean, we're out of time. Well, I'm very intrigued to ask you, and just yes or no, does this now affirm the executive's position, and then by executive I mean the presidency, to set up a body and to instruct that body to do whatever it is that they choose to do, whether it's an agency, department, or ministry? Yes or no? Does this ruling by the Supreme Court affirms the Nigerian executive?
If you have put me in a tight corner, I would say no. Because the presidency, the executive, the federal government cannot set up an agency to do whatever they like. They must still act within the ambit of the law. And that is, of course, also a message to the EFCC. No doubt, sometimes they are reckless in their activities, and this is the reason you will find this kind of oppositions. It is a call for the EFCC and other similar agencies to be law-abiding in the way they go about their duties.
All right. Well, very succinctly put there. I must appreciate you. Thank you so much for coming on, Deji Ajare. He is Executive Director, Sterling Center for Law. Once again, many thanks.
Thank you for having me.